of the underlying principle of taking back control. That has lain at the root of Brexit and its aftermath. The Leave campaign's slogan, "Taking Back Control," proved, of course, extraordinarily successful in encapsulating and tapping into the concerns of many voters. Anxieties over immigration levels and the perceived abuse of the asylum system were, in my direct experience of a campaign, paramount in Leave's success. But there was also the belief that the EU and its regulations stifled national initiative, freedom of action, prosperity, reduced political accountability. A narrative, I'm afraid, the Remain campaign proved unable to counter or to offer an alternative vision linked to the benefits of membership. So in voting Leave, the majority were making a demand of government and parliament for a change of direction for the United Kingdom in respect of our participation in building supranational frameworks, of which the EU was almost certainly our most important. The referendum was also a demand concerning what's expected of our unwritten constitution, which has become heavily entwined with the supranational frameworks the UK's helped to build. To understand where we've got to today, we have to start by looking at what's happened with some of these issues during the Brexit process and at just how revolutionary they might be. I think they also provide a guide to where we might be going. Now, we obviously shouldn't be surprised at Brexit producing political and constitutional problems. After all, our participation in the EU for 46 years was a process in itself of major change. In October 1971, Edward Heath secured the resolutions of both the Commons and the Lords for the United Kingdom to join the then EEC. A year later, the domestic legislation giving effect to our agreement to join was incorporated into our domestic law in the European Communities Act 1972, which gave primacy to EC law in our country. Parliament of the United Kingdom decided in furtherance of a treaty of accession that it believed it to be in our national interest to allow the Court of Justice of the EEC to override UK statute law and to allow the superior courts of the United Kingdom to do the same, to ensure conformity with EC law in all areas in which the then EEC and now the EU might have competence. And following that accession and the 1975 referendum, which confirmed the decision, 20 further treaties as our involvement deepened. And as the creators of the EEC and its successor, the EU, have actually been very concerned that the operation of EU law within its areas of competence shouldn't operate abusively and should uphold democracy, the rule of law, and the principles reflected in the European Convention on Human Rights, as well as other international treaties on social and economic rights, which all EU members are signatories. The scope of the treaties was progressively expanded through the Charter of Fundamental Rights of the EU to confer personal rights for EU citizens directly enforceable in national courts. The Treaty of Lisbon also introduced the new Article 50 provision, allowing a state to withdraw from the treaties on giving 2 years' notice. But despite Article 50 being available as a broad guide to how you might leave the EU, the reality is that prior to the 2016 referendum, no consideration whatever was given to how the United Kingdom might in practice extract itself from this very deep legal and economic involvement, if it chose to. Much of what's happened is undoubtedly due to this. But I think we also need to bear in mind, before I move on to the referendum events, that it's important to keep in mind that half a century of our EU membership has also seen parallel changes in our country's constitution, which are just as important as membership itself. And I sometimes think that in seeking to reverse the effects of EU membership, some of the promoters of Leave seem to have imagined that it was possible to return to a simpler constitutional and political system of untrammeled parliamentary sovereignty that had in fact long gone for other reasons. Let me just identify what I think are the key reasons for that change. The first, perhaps not the most obvious, concerns the extent to which subordinate legislation has snowballed as a means of delivering administrative policies. In 1950, there were 28 statutory instruments passed by Parliament, In 1966, 71, but in 1972, as we entered the common market, 1,100. At present, it's around 1,500 a year, although it has peaked at over 3,000. Most are never considered by Parliament at all, as we're seeing over the COVID regulations. Yet each is a use of executive power that is amenable in theory to review by the courts and can have a profound impact on the lives of the citizen in the way they're applied. So we shouldn't be surprised if in its wake the number of judicial reviews has grown exponentially, as well as administrative decisions made under them that have been challenged for illegality, that's excessive powers, unfairness procedurally, and irrationality. In 2018, over 3,500 claims were lodged compared to a handful per annum in the mid-1960s. But insofar as that's fueled criticism by politicians of judicial interference in the work of the executive, perhaps the question they ought to ask themselves is how this has happened and what exactly the consequences would be if all those statutory instruments couldn't be scrutinised in our courts. Leaving the EU is not making a difference to this at all. Second driver, which I think is linked to the first, is of course our adherence to the European Convention on Human Rights. We helped draft it in the late 40s, consequence of the Nuremberg trials after World War II. It was to give the aspirations of the UN Charter some possibility of implementation in practice, but the member states of the newly created Council of Europe created it and agreed that its terms could be adjudicated on by an international tribunal and bound themselves under Article 46 to observe and implement its findings made against them in a particular case. 1966, we were one of the leading advocates of allowing the right of individual petition to the court. Once that came in, it allowed for a growing flow of cases to the court and a series of landmark cases, challenged and halted practices which were once considered acceptable in Western democracies, which would now be seen as entirely unacceptable by the vast majority of the public, including, I might add, occasionally giving us a small jolt to some United Kingdom complacency about our own practices. Cases like Ireland and the UK in 1978 on British interrogation techniques in Northern Ireland springs to mind. It was the volume of cases going to Strasbourg which led, in part, to the decision of the Labour government of Tony Blair to bring in the Human Rights Act, which of course allows claims under the ECHR to be brought in domestic courts for our own senior courts to interpret the meaning of the articles of the ECHR, guided but not bound by the jurisprudence of the Strasbourg Court. It can lead to the strike down of statutory instruments, declarations of incompatibility for primary legislation, and that inevitably raises some degree of controversy. Lord Sumption, in his Reith lectures, made the point that it's giving judges, when it's applying qualified convention rights, the ability to stray into the boundary between political and legal decision-making. That's made successive Home Secretaries and others angry, with the opinion being expressed that ministers should be answerable to Parliament and not the courts. Some want the Human Rights Act repealed and for us to leave the ECHR, and yet another initiative on changing the Human Rights Act has just been announced by the Justice Secretary, or at least hinted at. I'm not quite sure what its status is. And the most recent problem of cross-channel migrants has led, as you were saying, Dimitrios, to calls for the repeal of the Human Rights Act completely. But a return to pre-ECHR days would quickly expose a lack of legal redress for issues widely regarded as injustices. Finally, in this pre-list, devolution. Prior to it, the United Kingdom, at least in theory, apart from Northern Ireland, was governed as a centralised state controlled by ministers answerable to the Westminster Parliament. That, as COVID is showing, is no longer the case. In setting up devolution, Parliament gave to the Supreme Court the role of arbiter of the interpretation of its limits. And the Supreme Court has on occasion had to do just that. In a case which I appeared as Attorney General in 2013, the Supreme Court had to decide, following a Welsh Assembly decision to keep an agricultural wages board when it was being abolished for England, if the Agricultural Wages Board concerned agriculture, which was devolved, or employment law, which was not. Despite the fact that when the 2006 Devolution Act was passed, civil servants in both London and Cardiff treated the Wages Board as being part of employment law, the Supreme Court held, as it was entitled to do, that on statutory interpretation, it concerned agriculture. So I lost the case. A United Kingdom government might use the United Kingdom Parliament to reverse such a decision, but politically, that will often simply not be possible. So here again is an area of judicial growth in constitutional matters and a great change in the way in which our country is governed. And of course, the devolved administrations are bound for their primary legislation by the Human Rights Act, which could give rise to the quashing of their statutes on that ground, something that would be seen as unthinkable in the context of the Westminster Parliament. Now, I mention those issues because I think when you look at what happened during the Brexit process, each of them actually comes into play. The first big legal question, of course, was how you triggered Article 50. The government took the view that as the original adherence to the EEC had been by treaty through an exercise of the royal prerogative in treaty making, backed by a resolution of both Houses of Parliament, it could trigger Article 50 as an exercise of the royal prerogative and no statutory authorisation was needed. It could also correctly highlight that nothing in the 1972 Act excluded the use of the prerogative power to negotiate and adhere to treaties in respect of the EEC. Mrs. Gina Miller and others disagreed on the grounds that as leaving the EU had a massive impact on statutory rights conferred on UK citizens during the course of and through EU membership, then removing these by withdrawal from a treaty triggered by a prerogative act was outside the scope of prerogative powers. Nothing very new about that. It was argued it ran counter to an established principle set up by Sir Edward Coke in the case of proclamations of 1610. The king, by proclamation or other ways, cannot change any part of the common law or statute law or the customs of the realm. Mrs. Miller's challenge was joined by ones from the devolved administrations in Scotland and Wales that Brexit required the consent of their legislatures as it has a profound impact on the devolution settlements. Now, the majority view was that the 72 Act effectively constituted EU law as an entirely new and overriding source of domestic law. It also pointed out that as a consequence of EU membership, rights had been enacted by Parliament which were freestanding and not required by EU membership, such as, for example, the right of UK citizens to vote for the election of MEPs. Yet these were going to be removed without statutory authorisation if the government triggered Article 50 using the prerogative. The majority therefore concluded that a statutory authorisation was needed. The court was, however, unanimous that devolved administrations and their legislative bodies had no veto powers over the matter. That doesn't come as a great surprise. If they had, it would have implied that devolved administrations had an effective veto over foreign policy. It's quite clear it's outside their competence. Now, this case is very important. It should have been seen as a rather esoteric point of constitutional law. Significant boost for Parliament against the growth in the last century of executive power, but as was obvious would happen, Parliament actually passed the necessary statute to trigger Article 50. But a glance at the headlines and the response in the Commons might not have left you with that impression. The High Court and Supreme Court judgments and the judges who made them were accompanied by a vilification of the judiciary. The Lord Chancellor, Liz Truss at the time, shamefully failed to stand up for the judges against the tone of these attacks. There was a newly created theory that the judiciary was thwarting what was called the will of the people, a sound that continues to echo today and which the present government has done little to discourage. So, coming to my theme, taking back control started by creating almost immediate instability in our constitutional balance. Next problem was that the government didn't know what was needed to carry out Brexit. It brought in the EU Withdrawal Bill, that was described as a Great Repeal Bill, which sounds good for those wishing to throw off the European yoke and take back control. But it was actually nothing of the kind. On the contrary, it was intended to entrench and convert EU law into domestic law to avoid our falling into a void of lawlessness on the first day of our departure. And just how big a void this might be becomes easier to comprehend if I explain it was reckoned that at the time, EU membership involved 40,000 legal acts, 15,000 court verdicts, and 62,000 international standards binding on us. Now, the bill seems largely to have been forgotten. It actually kicked in at the end of transition on 1/1/21. But it shouldn't be, because actually what it does is to stand the principles of EU law on its head. It takes EU law, but rather than retain it as a block, it tries to discard elements of it which didn't suit the government's political agenda. And the key thing to understand is that the legislation reduced the Charter and general principles of EU law to no more than interpretative aids. So all those protective rights, which were previously provided to ensure EU law couldn't operate abusively against individuals or companies or others, evaporate, leaving only the possibility of a challenge under the Human Rights Act. The justification for this was it would be wrong as we were leaving the EU to allow any element of judicial supremacy inherent in the way EU law operates to survive, as it offends parliamentary sovereignty. The alternative, allowing our own Supreme Court to fulfill that role, was rejected. And that immediately creates an anomaly. Principal complaint about EU law is either forced on Parliament, which then had to enact it, or worse still, could in some cases be directly imposed on us by the Commission. Yet to maintain predictability, we preserved its supremacy in relation to pre-Brexit primary legislation. We're also treating all direct EU legislation as primary for the purpose of the Human Rights Act, except for CAP regulations, even though a lot of it has been replaced, has the character of secondary legislation. It may be years before it's replaced by our own domestic laws. In the meantime, challenging it, if it actually leads to injustice or abuse of power, will in practice be difficult. In a remarkable act, the Schedule 1(2)b leaves open the possible creation of the right to challenge retained EU law for being invalid, but only if the challenge is of a kind described or provided for in regulations made by a Minister of the Crown. I can't think of any other example of an important legal right being created or denied in such a fashion by the executive. I should add that the challenge is only to retain EU law for being invalid at the date of exit. The Act also had the most extensive Henry VIII powers probably ever seen. In fairness, they were probably needed to bring Brexit about in the time constraints under which the government was operating. But it did mean that important legislation, such as the Equality Act, could be amended by this method within the permitted period. Also powers to prevent the devolved administrations from amending any retained EU law, even if this fell within their areas of competence, because otherwise it could impact on maintaining legal uniformity throughout the United Kingdom, which presaged the later disagreements we've had with the Internal Markets Bill, which I shall come back to in a moment. Last, there was, at the beginning, the infamous Clause 9, now I think 13, which allowed the government to enact statutory instruments to take us out of the EU in furtherance of any withdrawal agreement that might be reached even before we knew what it was, including changing the Withdrawal Act itself. Now, the point I would make is that the complexity of all this goes against Lord Bingham's first principle of the rule of law, that the law must be accessible and, so far as possible, intelligible, clear, and predictable. The start of the bill, there was great disquiet by the senior judiciary about the lack of guidance as to how they were supposed to apply post-exit CJEU authorities, and a concern that it was in fact going to politicize them, which doesn't exactly suggest that they were trying to take over. So the bill went through Parliament. It was undoubtedly improved. Some excessive powers were removed, and a system put in place for parliamentary scrutiny of the numerous statutory instruments that were going to be needed. And that was done through the efforts of the Commons Procedure Committee. I was successful in leading a rebellion which stopped the mischief of Clause 9. That's since been described as ensuring a meaningful vote for the Commons at the end of the negotiating process, but actually that wasn't what I was aiming to do at all. What I was aiming to do was to require statutory approval of any withdrawal agreement before any of the statutory instrument powers in the Withdrawal Act could be used to implement withdrawal. In practice, it made these powers redundant, and the Withdrawal Act, Agreement Act 2020, repealed them because it provided the necessary statutory approval that should have been programmed in the first place. Debates over the Withdrawal Act also became a battleground on ideological terms as to whether the United Kingdom could or should leave the EU with no deal. A minority but significant number of Conservative MPs were determined that our exit should not be delayed or any possibility of reconsideration of Brexit take place in the event of there being no agreement for leaving or an agreement being reached for departure, which was rejected by the House of Commons as being unsatisfactory. Rather extraordinarily, they persuaded the government to put the date of departure of the 30th of March 2019 on the face of the bill, so it would need primary legislation to change it, with the plain intention of ensuring that we would simply trolley, perhaps I should say shopping trolley, over the edge if no agreement had been concluded by that date. That led to the first major constitutional crisis and a standoff on consideration of Lord's amendments, which was eventually compromised by its being possible to change the date by statutory instrument. There was also a debate over the process to be followed in the event of a deal being rejected or there being no deal. An amendment was passed to provide for a sequence of votes which the government insisted should be in neutral terms so that the Commons could not impose an alternative view to that of the government, but promised that the Commons would have full opportunity to debate options if this issue arose. Thus, the constitutional crisis of 2019 was laid by the way in which the legislation in the Withdrawal Act was framed in the year before. Finally, in this consideration of the Withdrawal Act, there was the devolution aspect of it. Although the bill was amended to try to meet some of the objections of the devolved governments and ultimately supported by the Welsh government, the Act provided to depriving devolved authorities of areas of competence, and thus started to create another constitutional crisis between the United Kingdom government and the devolved administrations. And all this generates uncertainty and the capacity for litigation in future. But I think more tellingly in the context of today's talk, it demonstrates that when faced with a complex problem, cutting through it soon becomes more important than respecting the constitutional principles, without which the United Kingdom cannot work properly, and which bizarrely Brexit was supposed to be reasserting. So we have change being carried out in the name of tradition, but being done in a way that a constitutional traditionalist would deplore. And that too generates instability. Theresa May, of course, strove to reach a deal with the EU, stabilise our politics. I have no doubt that was her intention. But the nature of any deal proved divisive because of the lack of prior focus and the fact that any deal implies adhering to some EU rules, which undermines the rationale for leaving in the first place. Whilst wanting to leave the single market, which the United Kingdom under Mrs. Thatcher had gone to so much trouble to create, Theresa May still wished to retain a close alignment with the EU to allow for frictionless trade in goods and close cooperation on security and foreign policy. Key issue was the future of Northern Ireland, the complexities of the British-Irish relationship. Implicit in the Belfast Agreement of 1998, that it depended on the shared EU citizenship across the island of Ireland with freedom of movement and trade. As our continued participation in the single market and the customs union was ruled out, it meant that in any event, special arrangements had to be made for any withdrawal agreement to guarantee the continuing function of the Belfast Agreement. And as Theresa May was unwilling to allow any circumstance to arise that could damage the integrity of the United Kingdom, it led to the creation of the backstop, or Northern Ireland Protocol, being agreed, that would have maintained alignment on tariffs and regulations for the whole of the UK and the EU until such time as a way could be found and negotiated to allow for divergence through an alternative agreement without the need for border checks. I leave aside whether that would in fact ever have been possible. It was those arrangements that were then fiercely denounced by some MPs, including the current Prime Minister, Mr. Johnson, who described it as a vassalage clause tying us forever to EU regulations. It led to his resignation from the government, that of other ministers when the outline of the agreement became clear in July 2018. The agreement, as negotiated, was then subject to fierce debate, failed to get through the Commons on 3 occasions between January and at the end of March 2019, when it found it after the Speaker had ruled it could not return in its original form, and a third time in a slightly different form thereafter when the Speaker ruled it couldn't be placed back before the House in its original form. Meanwhile, in January 2019, the Speaker reinterpreted the standing orders of the House of Commons to allow for votes that would allow a majority of the Commons to determine its business, removing that monopoly power from the government, where it had been, the government had had this monopoly since about 1906. Following an emergency extension of the Article 50 process by agreement on the 20th of March for a short period of a fortnight, the Commons, using its new powers to command the order paper and with the consent of the Lords, enacted on the 8th of April 2019 the EU Withdrawal Act 2019, which required the government to secure a lengthy extension, which the EU duly gave us for 6 months to the 30th of October. Despite efforts to secure a compromise with her own backbenchers, Theresa May was then forced to resign. Johnson became Prime Minister on the 24th of July, with a promise to take us out of the EU, either with a new deal without the UK backstop or with no deal at all. When thwarted, politicians get tempted to look for draconian solutions. During the campaign for the Conservative leadership, the suggestion was first raised, but not interestingly by Johnson, that the government should consider getting rid of Parliament by proroguing it so as to force through Brexit against the obstruction of a majority of the Commons. This, I think, was dependent on this newfound theory that the will of the people justified it. It was a reflection of the anger of hard Brexiters at the Commons' insistence in April on forcing the government to extend the Article 50 period. Johnson indicated he didn't subscribe to this idea. It was, in the context of a modern parliamentary democracy, an unprecedented thing to suggest. A prorogation has in recent times only been used to bring about a short break between parliamentary sessions or a short extension to a general election period. But anxiety over this became sufficiently great that immediately after his arrival as Prime Minister, Parliament amended the Northern Ireland Executive Formation Act 2019 to try to require Parliament to sit on at least the 9th of September and the 14th of October 2019 to try to head this off. It also led to the launching of a petition in the Court of Session in Scotland seeking a declaration that any prorogation in the circumstances of a run-up to Brexit would be unlawful. The UK government response to this was it had no intention of doing any such thing. This was in fact an outright lie, as became clear in the Supreme Court when the documents were eventually disclosed. Prorogation was then ordered in the Privy Council on the 28th of August, but fortunately it couldn't kick in until the 9th of September because of the need to have the House sitting for the Northern Ireland Executive Formation Act. Because of strong suspicions that the government was lying over whether or not there would be a prorogation, MPs returned to Westminster on the 3rd of September and immediately passed a motion to seize control of the order paper the next day, and on the 4th of September passed the European Union Withdrawal No. 2 Act 2019, which got royal assent on the 9th of September, the day of prorogation. This required the Prime Minister on the 19th of October to seek by letter in the form scheduled in the Act, an extension of 3 months to the Article 50 process from the European Council, unless by then Parliament had either approved the withdrawal agreement or approved leaving without one. Parliament could, however, do nothing about being prorogued. The challenge in the Scottish courts initially failed on the basis that the issue was non-justiciable. The same happened in the divisional court. In England, where the Lord Chief Justice was of the opinion that prorogation was a matter of high policy on which the courts were not suited to pronounce. But the inner house of the Court of Session in Scotland held that the advice that the Prime Minister had given the Queen was justiciable, that it had been motivated by an improper motive of stymieing parliamentary scrutiny of the executive, and that it and the prorogation that followed it were unlawful and thus null and of no effect. And ultimately, the judgment of the Supreme Court followed this reasoning closely. It also set up a number of important principles. It clarified the nature of prerogative power, a power recognised by the common law and exercised by the Crown, on advice in this case from the Prime Minister. The fact that a dispute over it concerns the conduct of politicians or a matter of political controversy, not a sufficient reason for the court not to consider it. The argument that the government should be answerable to Parliament alone for its action on prorogation was rejected. Firstly, because the effect of prorogation was in practice to prevent accountability to Parliament, but in any event, because the power had to be exercised within the scope of the law on which only the courts can rule. The case of proclamation was again cited. The king hath no prerogative but that which the law of the land allows him. Our country may have no written constitution, but it doesn't mean that we don't have one. A fundamental principle is that of parliamentary sovereignty, which will be undermined if Parliament could not sit to scrutinise the executive. An unlimited power of prorogation would therefore be incompatible with it. The conduct of government by a Prime Minister and Cabinet collectively responsible and accountable to Parliament lies at the heart of Westminster democracy. It therefore follows that the relevant limit on the powers to prorogue Parliament would, if the prorogation had the effect of frustrating or preventing without reasonable justification the ability of Parliament to carry out its constitutional functions as a legislature and as the body for the supervision of the executive, be unlawful, and it entitled the court to intervene if the effect was sufficiently serious. As the Prime Minister had been unable to show any reason, let alone a good reason, for the extraordinary length of the prorogation, and no affidavit, you will recall, was actually filed because it would then have disclosed the truth about the timing and the motive, it followed that the advice to prorogue was unlawful. The outcome was, in my view, of a very different order to the first Miller case. That was about a complex point of law. The government lost the prorogation case because it was abusing its powers. It didn't help its case by the threats that were coming out from 10 Downing Street at the time that Johnson would refuse to write the letter requesting the extension, which of course he eventually had to do. The actions of the Supreme Court were not revolutionary at all. In fact, they were absolutely in line with past decisions on a massive abuse of power by use of the prerogative. The revolutionary behaviour, which we're going to come on to consider in a bit more detail now, was that of the Johnson government. Thwarted from being able to credibly threaten or implement a no-deal Brexit, the Prime Minister then, of course, changed course, signed a withdrawal agreement almost identical to that of Theresa May's. But crucially, he abandoned the UK-wide backstop for one that applied to Northern Ireland only, and thus had the potential to create a border down the Irish Sea between Great Britain and Northern Ireland if there was no trade agreement for frictionless trade. And although he secured the second reading of the ratification and incorporation of this agreement into our law in late October 2019, the risk that the reality of the agreement would be exposed at the committee stage of the bill made him then seek a general election that Jeremy Corbyn very kindly gave him, oblivious of his own party's unelectability. The Prime Minister won with a majority of over 80 and was then able to push the Withdrawal Agreement Act 2020 through with no difficulty and virtually no scrutiny. The irony that the withdrawal agreement required reviving the work of the hated 1972 Act to make it last a bit longer, or that its effects in Northern Ireland might in fact be permanent, if no satisfactory deal was reached, was glossed over. Achieving the goal of leaving in this fashion comes at a price. As we've seen, negotiating a trade and cooperation agreement has proved difficult, both in relation to the deal itself, but also in relation to the United Kingdom government's relations with the devolved administrations. The Internal Markets Bill was needed if the UK was to preserve an internal market with the repatriation of powers from Brussels. But like the Withdrawal Act, it highlights the complexities of recreating a UK single market in a post-Brexit and post-devolution world, with the Scottish and Welsh administrations denouncing a Westminster power grab, although those powers are largely theoretical, as they were previously exercised by Brussels. But with resentment at Brexit, particularly in Scotland, now linked to separatism, it's taken on the character of a conflict that may be very hard to reverse. Many powers, such as food labelling in energy efficiency and support for farmers, have been repatriated from Brussels to the devolved governments. But at the same time, the United Kingdom government has required that goods and services provided from elsewhere in the United Kingdom to a different standard will also have to be accepted. So if the United Kingdom government were to accept chlorine-washed chicken for England in a UK-US treaty, Scotland, Wales and Northern Ireland would also have to accept it. There is an office for the internal market to help settle disputes, but it's merely advisory. The Act prohibits both direct and indirect discrimination against goods from elsewhere in the UK. And in reality, this is a bill that reaffirms the power of Westminster and Whitehall. It's this veto power that has been made into an article of opposition by the Scottish and Welsh governments. But of course, it's fair to point out, if there was no mechanism for resolving differences, then potentially the single UK market could collapse. And as notable was the last-minute decision to insert new clauses into the bill that allow the government by statutory instrument to ignore the clauses of the Withdrawal Treaty and override the Withdrawal Agreement Act if necessary in order to maintain a single market with no checks between Great Britain and Northern Ireland if there's no trade deal. As the Secretary of State for Northern Ireland admitted, this was a breach of the United Kingdom's obligations under the Withdrawal Agreement. To threaten such a breach and indeed carry one out by introducing a legislation which immediately breaches the requirement of good faith both in the Withdrawal Agreement itself and the one implied in the Vienna Convention on International Treaties is an entirely unprecedented moment in our modern political life in this country. We're currently signed up to about 14,000 international treaties, 800 of which have arbitral mechanisms to resolve disputes. Threatening to breach a treaty unilaterally by passing domestic legislation to do so is massively damaging to our status as upholders of the international rules-based system we have helped create. The decision to bring in these clauses prompted the resignation of the Treasury Solicitor and led to the resignation of the Advocate General for Scotland. It also backfired, as there was a rebellion in the Commons and the Lords blocked it. Even some Brexit supporters were appalled at what was being done. This raises serious questions about the way government is now functioning, from the breach of the ministerial code in bringing such legislation forward, a failure of the current Attorney General to object to it, and indeed the extraordinary arguments justifying it as acceptable based on legal opinions that are not regarded by most lawyers as being credible, including an extraordinary denial that the ministerial code had not been breached when it plainly had been. A final issue was to attempt to oust judicial review of these statutory instruments relating to the Northern Ireland Protocol in the bill. This too raised constitutional issues of importance and threatened a direct clash with the courts before it was abandoned. Today, we are seeing the political consequences from these events, and they don't show any sign of going away. The unwritten rules of conduct for the executive and parliament create the trust which is essential for a political community to function and for minorities to accept majority decisions. They prevent the abuse of executive power and support the right of opposition, and are one of our country's defining strengths. Over prorogation, those rules were ignored by the Johnson administration, both in the decision and by the way it was accompanied by an onslaught of disinformation and lies from number 10 Downing Street. Now, the authors of that disgrace have now parted company with him, but the legacy remains. The cavalier disregard for the independence of the Commons, shown in Johnson's attempted interference with the Standards Committee and Commissioner's report on the conduct of Owen Paterson, is entirely of a piece with it, and suggests that he will continue to behave in a way that is corrosive of the effective functioning of a parliamentary democracy. The government continues to suggest that it might pursue policies to try to reverse the constitutional clarifications the legal challenges brought in. There's certainly some obsession here with what is called judicial power. Fortunately, the review of judicial review carried out by Lord Foulkes resulted in recommendations that were very minor and in legislation that really makes only very limited change. But there is the ouster clause on judicial review for the dissolution bill now published to replace the Fixed Term Parliaments Act, and suggestions that the Human Rights Act may be radically amended and that we might leave the European Convention on Human Rights. I find it difficult to say how serious those suggestions might be. If done, it's worth noting that they would make parts of our trade and cooperation agreement with the EU unworkable, as the Trade and Cooperation Treaty presupposes continued adherence by the United Kingdom to the ECHR. Brexit threatens the integrity of the United Kingdom because it's been carried out in disregard of the consequences of devolution to Scotland and the Belfast Agreement in Northern Ireland. That disregard was clear in the Prime Minister's dishonesty over the consequences of the Northern Ireland Protocol and over the government's handling of the repatriation of powers from Brussels. In fairness, however, I suspect that whatever the government's approach might have been, the First Minister and the SNP would have sought to make use of Brexit to further the cause of nationalism and independence. Brexit has effectively exposed significant differences of view on an issue of core national interest between different parts of the United Kingdom. This should come as no surprise. Junior partners in a national political enterprise like the United Kingdom have accepted historically the subordination of aspects of their political identity for the benefits of the Union, are much less likely to share the obsession with taking back control from the EU, even if nationalists in Scotland have separatist aims of their own. In Scotland, the economic arguments against independence are overwhelming, seeing that the SNP wishes an independent Scotland to rejoin the EU when 60% of its trade is with the rest of the UK. Its deficit between revenue raised from taxation and its public expenditure is so great without the subsidy of the Barnett formula that it couldn't meet EU membership criteria at present. But politics is not just about economics. Grievance and identity politics have a dynamic all of their own. This constitutional clash has been revived by Brexit when it looked as if it was going away. Confrontations over the next few years between Westminster and Edinburgh that have the potential to be highly disruptive and potentially fatal to our union risk diverting energy from more productive matters. Northern Ireland has undoubtedly contributed to a growth in support for unification with the Republic. But history shows that any disturbance to a status quo, after all, we've just seen it with Brexit, in Northern Ireland's case, it's accepted by many as the best default position available, may be very dangerous. Violence in Northern Ireland during the Troubles came from the actions of a very small minority. And there's no reason, I'm afraid, why the same couldn't happen again if a border poll were for a change, and that change was rejected by a small minority in the loyalist community. The long-term aspiration of those in Dublin politics for reunification has always been tempered for many, as indeed it is for many Irish citizens, by neither wanting the cost of paying for it or in enforcing it if it doesn't enjoy overwhelming acceptance. None of that diminishes the disruption and tension Brexit has caused there. the Northern Ireland Protocol and the problems of its implementation without breaching the spirit and letter of the Belfast Good Friday Agreement are obvious. It's the very opposite of quiet governance that every government should be seeking to give its citizens. And this really highlights for me the key consequence of taking back control. The revolution isn't really about the economy. The reduction in trade and commerce with our closest neighbours, estimated at 4% by the Office for Budget Responsibility, will undoubtedly be noticeable over the years, as will be reduced inward investment. And I doubt that this will be compensated for by deregulation of the financial sector or new trade deals, which at present there have been hardly any that are not replicating the EU's existing ones. But it's more about our world outlook as a nation. We talk of creating global Britain, but for all our aspirations to be involved globally post-Brexit, the evidence of change at present points the other way. I saw this as chair of the Intelligence and Security Committee, as visiting interlocutors from the Middle East raised with us their concerns at the UK's declining influence there as we were looking inward. It's evident in the loss of our seat on the International Court of Justice, where we'd previously always had a judge. The government's decision to abandon our overseas aid target of 0.7% of GDP was telling, even if it is now apparently to be reversed. But I have no doubt most alarming for our allies of all was the clear intention to break international law in the Internal Markets Bill. It's irreconcilable with the government's insistence that our soft power has and will be demonstrated by our reliability in upholding the international rules-based system. A reputation for being reliable and having stable decision-making processes is being lost, and it can't be easily recovered. And this isn't just a one-off. We're close to doing it again over our attempts to strong-arm changes to the Northern Ireland Protocol and threatening to invoke Article 16 to depart from its terms in what is almost certainly a breach of our treaty obligations. Consequences can be seen at this very moment. We're currently involved in a largely sterile slanging match with France over cross-channel migrants, an issue which can in large part only be addressed by close cooperation with the French and the EU, has been poisoned by the distrust France now has of the Johnson government as being dishonest and unreliable over a range of issues. Because trust and influence are gone, along with the legal framework of the Dublin Agreements on asylum seekers, Johnson is left to resort to comedy comments, unilateral pronouncements, and tweeting what in common sense needs to be private correspondence. He then appears surprised that his French friends, as he keeps calling them, ignore him, or that his aims at the G7 were diverted by a spat over fishing licenses with them. This is not to say that the French are acting well or in their own best interests either, but it shows what happens when the basic building blocks of diplomatic engagement collapse under the impact of populist rhetoric, unworkable proposals, bad personal relations, and a total failure to see beyond your next soundbite to the needs of the partner with whom you are trying to reach agreement. Meanwhile, other key partners also look askance at how we behave. As a result, relationships become much more one-sided, as one can see with the USA, on which our dependency for security grows as our influence with the Biden administration diminishes. Another sign clearly present over the disagreements on the Northern Ireland Protocol. Far from having greater control over our future, we now have less. Another example was the lack of apparent EU engagement over COP26. When we were members of the EU, it would have been expected that the EU would put its diplomatic heft behind the agenda of a hosting member state with which it agreed on climate change. But this didn't happen because we're no longer members. Indeed, on foreign affairs and defence, we've deliberately chosen to turn down offers of a closer engagement from the EU. In the context of the growing menace from Russia and recent events on the Belarus-Polish border, this seems extraordinarily short-sighted. But I don't want to end on an entirely gloomy note. Although some commentators have argued that the UK unwritten constitution was broken by Brexit, I actually disagree about that. The remarkable feature is how resilient our Westminster Constitution proved to be under many of these stresses. The government behaving badly because it felt thwarted in achieving its goals during the Brexit process up to 2019, the response by the House of Commons, its Speaker, the House of Lords, and by the Supreme Court to the challenges thrown up showed to me that the checks and balances needed in a parliamentary democracy could still function, despite the media vitriol and the chaotic atmosphere, even if in the end the outcome wasn't the one which I myself sought. But the larger question remains if this will continue in future. Until the Patterson scandal and Johnson's overreach, the Commons, partly under the impact of COVID, had become little more than a rubber stamp to the executive, conferring wide powers on it with little scrutiny. Yet, as ought to be obvious even to Conservative MPs, they have a leader and Prime Minister operating well outside accepted norms of behaviour, abusing his powers, and relying on riding out the chaos created by both Brexit and his own conduct through gimmicks, as a substitute for his inability to deliver soundly based governance. Achieving that will almost certainly require two things. The first, I think, is a new Prime Minister, but the second, and as importantly, is a willingness as well to look at the reality of our country's position in the world and our international relationships, rather than living in the fantasy land of English exceptionalism that has characterized the entire taking back control process. Thank you.
Thank you so much, Dominic, for this extremely insightful, thought-provoking, as expected, of course, analysis of what happened with Brexit and the revolution at the constitutional and socio-political level that it has created, and the consequences of which we are currently confronted with on a daily basis, one might argue. And you have pointed there the significant disruption that we're experiencing at legal and political level. And of course, you have referred with more brevity to the economic impact that the consequences of Brexit are bringing to this country. I mean, I can't even begin to highlight the terror, one might argue, that one experiences faced with such a holistic picture relating to the various stages and the various levels at which we witness a significant departure from foundational principles of liberal democracy that have been and should be at the center of a modern democratic state like the United Kingdom, especially if one considers that the United Kingdom has been, as you rightly pointed out, at the beginning of the creation of the international community with regards to the Council, the creation of Council of Europe and the European Convention on Human Rights, for instance, that we paradoxically currently attack. I will not delay us here. There is obviously so much food for thought here, goes without saying, and I hopefully there will be time for me to come back with a quick reflection. But before we do that, I'm delighted now to welcome Jessica Simor QC to the panel, and we're very much looking forward to hearing your thoughts in discussing Dominic's thought-provoking speech tonight, Jessica. The floor is yours, Jessica.
Thank you very much, and thank you, Dimitrios. Thank you, Dominic. Well, it was an extraordinary survey of the last five years, and I think. I crucially think that the core of this relates very much to the unwillingness to face reality and to face truth. And I'm just going to make a few comments on the question of why this happened. So I'm afraid I'm also going to go back a little bit over the history. And I think perhaps the answer to this question comes ironically from the slogan itself, taking back control. Because the slogan essentially tapped into strong nationalist inclinations. Yes, people may have had real concerns, but the slogan itself was essentially a nationalist slogan. And in being a nationalist slogan, it of course promised the impossible on the basis of false narratives, as nationalist discourses generally do. And as such, it was a promise that required its advocates to use lies, both in terms of what the UK would gain from leaving the EU, and also what it was leaving. So that there were two lies: what we would get and what we were actually leaving. Taking back control was essentially never deliverable. And I would say that was, in a sense, the underlying cause and trigger for what I would describe not as the disruption of the status quo in law and politics, but rather as a new politics based on what is essentially authoritarian thinking, because the basis of it is the striving for executive power without accountability, whether accountability in Parliament or accountability before the courts. And Dominic Grieve, you gave various examples of this. I mean, in a sense, Schedule 1(2)(b), a minister deciding when a particular SI can be challenged, is an extraordinarily authoritarian approach to law, or the creation of vast Henry VIII powers. But there have been many subsequent examples, and one might think of the multiple appointments to the Lords in the past 2 or 3 years. But returning to the history, I would say that once the executive was faced with the vote in favour of leaving, which it knew was against the national interest, it had two choices. The first was to face up to the people and tell the truth, and the second was to double down on the lie in an attempt to keep the show on the road. And I'm afraid Theresa May chose the latter, no doubt for internal party political reasons. But by that time, the hysteria was so great, it would have taken a very powerful person to calmly face the country. And sadly, she was not that person. We can take just a few examples. She never explained to the people what had actually been decided, which was, of course, extremely limited, as you said, Dominic. No one had actually decided what it really meant, what returning to 1970 meant for our country. And instead, she chose to adopt yet more dangerous slogans. Brexit means Brexit, and we're going to make a success of it. Meaningless and indeed false by omission. No deal is better than a bad deal. A false slogan, just like taking back control. She chose to adopt a winners-take-all approach, which is an anathema to democracy. The winners became the people, and everyone else was labelled anti-democrats. The minority, a very large one, was to have no voice. And I would go so far as to say that she simply misconstrued democracy. She chose not to agree or even share a negotiating mandate with Parliament. Remember that the Commission in Brussels did do that. She chose not to share risk assessments, although that was surely a matter for everyone's representatives to understand. She chose not to put Article 50 before Parliament, but rather to accuse those bringing the case of being anti-democratic. And at her first party conference, she directly attacked the claimants and the lawyers who were representing the claimants. She chose not to defend the judges from the attacks as enemies of the people, but rather to defend the right of the press to attack them on the mistaken basis that that was democratic. She chose not to deal with the serious spending offences that the Electoral Commission had found beyond reasonable doubt had been committed by Vote Leave and Leave.eu. In Switzerland, that would have been enough to result in the referendum result being put aside. Rather, she defended a judicial review of her decision, not even to consider that question. And she took the same approach to the question of Russian interference. She chose not to investigate it. And we've still not seen the full report of your committee, Dominic. So at a political level, she was entirely captive to the slogan, "Take Back Control," a slogan that she had opposed. And somehow that infected everything and everyone, including the national media. Somehow our country was overtaken by fear and hysteria, which is not the best recipe for democratic discussion. And I'd suggest that this breakdown in our collective respect for truth and evidence is at the heart of the problems that we have today. We now have a catalogue of events that would have been extraordinary 6 years ago. They're now minor news clips, and day by day, one sweeps over the other. Some will be known by no one outside particular world. A convention, for example, to consult Treasury Counsel on a legal issue of national and international importance, namely the Internal Market Bill. Now, this might seem irrelevant, but the fact that James Eadie QC was not asked to advise about the decision to break international law, but rather a partner of the Prime Minister's special advisor, who also was instructed in the prorogation case, as well as a barrister who had been active in Vote Leave and was highly praised by Dominic Cummings, raises serious questions. The fact that Dominic Cummings clearly intervened in telling the Attorney General whom to instruct is actually important. Independent counsel instructed by the Attorney General without interference by political masters ensures independent advice. And going to those who will tell you what you want to hear is not good for the national interest for obvious reasons. And the same, of course, goes for public procurement. And another example we heard this weekend was that an email has apparently gone out around Whitehall that has been leaked, telling departments, civil servants, that they shouldn't invite speakers who don't support the government and that their social media accounts should be looked at and checked before they're invited. So, for example, someone like myself will no longer presumably be invited to give legal seminars to the civil service, as I have frequently done. What the Vote Leave group discovered was that none of this matters in terms of voters. You can change public institutions, you can demand loyalty, you can distort truth without voters noticing. And the Vote Leave crew understood that the few who notice are simply not important. And thus, under the auspices of what might look like democracy, i.e. voters, the mass of voters, you can carry on and do what you like. Essentially, the key basis of our democracy, which I would say is honour and respect by those in charge, simply dissipated in the face of a leader who repeatedly showed that he, and I'm now talking about Johnson, did not respect the rules. Prorogation, Internal Market Bill, breaches of the Ministerial Code, the Patterson Affair, to name but very few. And he was, of course, also egged on by Dominic Cummings. And I just want to give a tiny quote from his March 2019 blog, because I think it's actually so revealing. Dominic Cummings wrote, and this was public, also, don't worry about the so-called permanent, in inverted commas, commitments this historically abysmal cabinet, that was Theresa May's cabinet, are trying to make on our behalf. They're not permanent, inverted commas, and a serious government, one, not cowed by officials and their bullshit legal advice, in inverted commas, with which they have herded ministers like sheep, will dispense with these commitments and any domestic law enforcing them, i.e. a complete disrespect and disregard for law, the absolute power of the monarch, one might say. Now, I always felt very much that my biggest fear post the referendum actually was corruption as much as leaving the EU. If people know that the only way to get ahead is to toe the line, cheat or bribe, eventually that will infect all levels of society. None of us will be willing to respect the rules, and fewer of us will be willing to speak up. And I suppose that leads to my last point, and it's a point very similar to that made by you, Dominic. The core of democracy is surely trust, and what Vote Leave did was end trust. those in charge are highly attuned to what they need to do to retain popular support, perhaps even to guarantee it. And they realize that truth is not so important for that. But once you've destroyed trust, truth essentially becomes irrelevant. And I'm certainly not the only one who feels this. Sir John Major recently told the BBC that the UK is politically corrupt, and Lord Evans, the chair of the Committee of Standards in Public Life, warned that we could slip into being a corrupt society. So those are my thoughts, that really corruption is also core. If we want democracy, we have to have truth and honesty. And those are my real concerns.
Thank you so much, Jessica. There couldn't have been a more appropriate follow-up to Dominic's analysis. And the two taken together present us with, again, a disruptive, extremely worrying view of where we are today. Politically, socially, constitutionally, in relation to trust or the lack thereof that we can place on our democratic institutions. I do recognize, and I'm thankful for Dominic ending on an optimistic note, the levels of resistance, the reflexes that Parliament and our unwritten constitution have demonstrated in response to the crisis that we have been experiencing at the time. However, again, taking all those threats together to the rule of law, to international human rights, the domestic legal order, you've spoken about corruption, about the absolute power of the monarch, about the executive wanting to quite desperately to avoid being held to account. You've spoken about trust destroyed and truth becoming irrelevant, Jessica. Dominic has spoken time and again about the damage to the United Kingdom's international reputation. He's demonstrated to us that the threats to break international law in the context of the international markets bill were truly unprecedented. And he's spoken about the serious threats that relate to the UK's future as a union that is, and the paradox that taking back control really generates in relation to Scotland, in relation to Ireland, Northern Ireland, more specifically. Really, I mean, the list is very long, and we have only had less than an hour and 30 minutes to go into that. And I'm sure that if we were to provide us with more time, then immediately we would be confronted with an even longer and even more worrying list of examples of disruption to foundational principles of liberal democracy. I want to take us very quickly to some reactions from the part of our audience. And perhaps once I've done that, Dominic, I don't know if you were willing to offer a quick reflection on some of the thoughts that Jessica expressed just now.
So very happy to do so. Yeah.
Thank you, Dominic. So the reactions from our audience. First of all, I think there is undoubtedly a sense of pleasure to connect with you again, Dominic, in this context, and a sense of loss at the same time that we cannot have you in Parliament right now making these points and communicating these points with the conviction and the evidence-based approach that you have always taken. So comments range from "well said, Mr. Grieve," "God, I miss ordinary, decent conservatives in government," to simply pointing out that it was an excellent presentation, that the audience, members of the audience, are pleased that you didn't hold back Excellent as ever from Dominic Grieve. There is a number of messages there that go in this direction. And then there are a couple of really interesting observations, again, from members of the public, members of our audience tonight. So first of all, a question, and both you, Dominic, and Jessica, feel free to come in and provide the response. Did the Constitution only survive? I suppose that is in connection with your concluding observations there, Dominic. Did the Constitution only survive because Boris Johnson didn't have a majority prior to the 2019 election? In other words, will our Constitution survive, or would our Constitution survive similar attacks if they were happening now? And we were just saying that they are indeed happening now.
But I took that question as being quite an interesting one, which hadn't occurred to me before, which is, in a sense, what if Johnson had become Prime Minister in 2016, when it looked as if he might do, until he decided to withdraw from the Conservative leadership contest. He would have found implementing Brexit very difficult. After all, Theresa May, who was a vastly superior person to Johnson, found it hard to do. And Jessica came up with some very pointed critiques of Theresa May's conduct, which I think are, at least in part, justified. I think her intentions were good, but I think that she simply took the view that Brexit had to be implemented. And then, having done that, she tried to find the best way of doing it as she saw it, but she never had the imagination, in my view, to look beyond the consequences. So, to my mind, the consequences became, as each month went by, became worse. But she never was able to make that leap to saying, well, they're so bad, we have got to do something other than just implementing Brexit. And to that extent, she then got herself tied up in knots. And once she'd lost the 2017 election, well, then she'd had it, because she was in hoc to the European Research Group, the ERG of the Conservative Party. And she was never going to be in a position to get over that. And so ultimately she failed. Now, what if Johnson had become Prime Minister in 2016? In view of his behaviour, post-2020, I mean, the one justification for his behaviour is he had a parliamentary majority and he'd won the 2019 election. So in a sense, he justifies himself on a rather robust, old-fashioned basis. I have a majority, therefore I can do what I want. And indeed, there's a lot of Johnsonism which is about a return to this old world, unconstrained by conventions, nitpicking laws, and all the other things. Of course, prior to 2019 election, the evidence was, under the influence of Cummings, that he actually behaved in what can only be described as appalling fashion. Prorogation, the extraordinary smear campaign. I mean, I have to say, I'm not a detached observer on this because I was at the receiving end of it. But the fact that he had a number 10 spokesman ring up a national newspaper and say that I, Hilary Benn, and Oliver Letwin were both in the pay of all three of us were in the pay of foreign governments, which led to some very direct death threats. Something which he never withdrew, and he actually endorsed the following day when he was doing a MAR interview, saying, I believe there's something that needs to be looked into here. I mean, this was, I understand, I've never had one. I eventually got an answer from the cabinet secretary who said, this is all. We didn't say, he didn't apologize for the smear, but he confirmed that the suggestion we were being investigated for this gross misconduct was entirely unfounded. So it was a lie. Also, my understanding is that a number of UK ambassadors abroad complained to the Foreign Office that the behaviour of doing this was so like that of strongman governments attacking oppositions in terror, effectively, that they were deeply concerned about the impact it was having on the UK standing abroad. Now, of course, he did that, or went along with it, in 2019 because he didn't have a majority. So he was willing to behave in ways that at that stage made me realise that his prime ministership was going to be disastrous for our country, as indeed it has proved to be, even when he has one. So I think we should be thankful that we didn't get Johnson in 2016, because I think it would have been much, much worse. And although I suppose it's just possible that in the circumstances, the strength of rebellion on the Conservative benches might have been more marked and might have brought the Johnson government down at an earlier stage, when you had a big difference between having a majority of 16 and a majority of 80. So I think that's how I see that question. And as I say, for all the problems we've had, I don't want to be completely negative. Our constitution has been very resilient. But what's missing at the moment is the willingness of MPs to look in the round, and I remember my ex-Conservative colleagues, at what Johnson is doing and how he is doing it, and come to the conclusion, which is the conclusion any reasonable person must come to, that this is somebody who cannot be left in office. And at the moment, they're just not able to make that leap. And I do find that quite worrying about the state of our democracy. But Jessica may have something to say on
that. Jessica, do you want to follow?
Well, funnily enough, I confess that after the referendum, my initial reaction was Johnson has to be Prime Minister, because he's the only person now who could turn it round and basically stop us leaving. But that was a long, long time ago. And I remember sort of frantic calls with various people about this issue. But I thought he'd be the only person who could sort of bluff his way to actually say, well, we sort of left, but we didn't really. But of course, you know, that's not taking into account the wider politics, and that's looking back on it. I think now he's obviously completely out of his depth. And I'm afraid that there seems to be so much fear and the people he's basically put into Parliament, because it's not just that he has a majority, it's also that a vast number of that majority are made up of hand-picked people who are his people. So yes, I would very much agree.
This series has set out to explore the question of whether we are experiencing a new winter of discontent. Now, in view of the threats that you have both highlighted to democracy, the rule of law, international human rights, one, I think, would argue with a lot of conviction that the events that we're currently would very much justify coming to the conclusion that we are indeed, or should indeed be, experiencing a new winter of discontent. Now, do you feel that is the case? I mean, as far as the public is concerned, does the public show the reflexes that one might expect them to do? And if not, what is the explanation for that? I mean, why are not people up in arms if everything that you have highlighted tonight is happening and has indeed been happening for a few years now? I mean, we're not talking about isolated events here, but a chain of catastrophic events that demonstrate the existence of very significant threats to what the UK stands for, ideologically and politically. So what is the reason? Why has the public not why is the public not up in arms? Dominic first, and then maybe Jessica.
I think one has to look at some of the underlying issues. But clearly, it's possible that there may be a massive shift in public opinion. Part of the problem, I have to say, is that at the moment it's still very far from clear that there is an alternative government available. The Labour Party has got itself into such a catastrophic mess under Corbyn, and although Keir Starmer is trying very hard to extract it, it's still very inward-looking, and I don't think it has as yet reconciled the contradictions that lie within it. And as long as that's the case, it doesn't come across as a credible alternative government, although it may be moving in the right direction. So particularly when people do have, I think, and I don't think we can ignore this in Britain today, a series of anxieties which probably push them towards what I would describe as populist views, particularly over issues like migration. it's difficult for them to go anywhere else unless they start hemorrhaging off at the extreme edge to go back to some reconstituted Nigel Farage party, which can't be completely excluded. There was some comment in the press that he might reappear. So we're living in a world of disturbed conditions. And so I think there is a tendency to cling to the Conservative Party because of fear of something worse. Now, we may think that that's a mistake. But Jessica might well think it's a mistake, but I have to say, that I think is the reality. And then you have the problem. We can't ignore the fact that a very large number of people voted to leave. One of the advantages Boris Johnson has is that actually getting rid of Johnson for Conservative Party members or parliamentarians carries with it still the baggage of almost impliedly admitting that Brexit was a mistake. And that, for obvious reasons, is very, very difficult for people to do. That said, I happen to find myself in the presence of a constituent today, or an ex-constituent, who had been vociferous in wanting to get rid of me when I took the stand I did in the early part of 2019. I don't think he's changed his mind on getting rid of me, but he's certainly changed his mind on Johnson. To the point of being furious with it. And it was that fury which I think communicated to Conservative members of Parliament over the episode of Owen Paterson, because I think they felt personally sullied by the way in which Johnson had used a 3-line whip to make them do something which many of them were very uneasy about. So we may just begin to see the reawakening of conscience about the way the Johnson government behaves, but I still think we've got a long way to go. But the truth is, he's had pretty plain sailing. And there is a tendency in Britain, and we've seen it before, particularly with COVID also in the mix, that as long as people are not seriously adversely affected in personal terms by the way the government's behaving, the fact that they're watching chaos around them as long as they can be cozy in their own homes is something they almost rather take to. The whole of the Brexit episode was laced with people writing to me and saying, Mr. Grieve, where is your Dunkirk spirit? And I thought to myself, what are these people talking about? Why should I wish to inflict Dunkirk on my own country when it was one of the country's greatest disasters? But there is a strange, I don't know what it is, almost a masochism of the English exceptionalism thrives when under pressure. And Johnson feeds off that.
Thank you, Dominic. Jessica? And I'm also conscious of the time. We're already about 10 minutes past the point where we're supposed to finish, which is simply an indication of the interest that this has generated, of course.
Yeah, so very briefly then, I find this very perplexing. I think all the things that Dominic said obviously play. The constant wave, the day by day, the week by week outrage doesn't help either. I mean, when does one go out onto the street and demonstrate, really? It's one thing after another. But also, it partly possibly is the nature of the issues. So for me, stating in Parliament that you intend to break international law and oust the jurisdiction of the courts was about as bad as you can get. But for friends of mine, perfectly educated people, it wasn't particularly important. Same with prorogation, all rather amusing, but not particularly important. Again, for me, closing down Parliament, I mean, how bad can you get? It really was the Paterson affair where friends of mine were saying, well, this really is too much. So I think that's very interesting as well, because I think we forget that the law, being, our sort of lifeblood and so essential in our understanding of democracy, is not that important necessarily, or people don't quite realize how important it is. And that includes people who are educated to university level and above. So I suppose it's that too. Interestingly, where we do see demonstrations, as Dominic says, is where people feel personally affected. the demonstrations about vaccine passports and mask wearing. I mean, people are willing to get on trains and demonstrate about that quite vociferously, but they really don't seem to care too much about corruption. So I think it's very perplexing, very, very difficult to understand. And I think in another country, things would be different. I would say it would definitely be different in France. So I don't know about Greece, Dimitrios, but I mean, I don't think that the French would have taken this long to get out onto the streets.
Yes, I suppose the French have a tendency for a historical tendency for that. I suppose perhaps there are lessons here for the conservative government too. Perhaps they should not be as complacent as they currently appear to be. I mean, there have been a few indications in recent weeks of better polling or political fortunes for the Labour Party, and nobody knows when all the events that you have so carefully documented today, both of you, pile up, and to an extent that the situation boils over, and suddenly there is a reverse of fortune. So I suspect from the viewpoint of what can be done as we move forward, it's a question that a number of members of the audience have been asking, in addition to observing that you have perfectly demonstrated the significant defects constitutionally and institutionally that we have witnessed over the last few years, and asking with anxiety, that's how I perceive it, what can be done? How are we moving forward? And perhaps that gives me the opportunity to highlight the importance of the work that you do, Jessica, the work that you do, Dominic, including in the context, quite modestly, but still including in the context of conversations that happen at university, and through this channel, this means of communication, where the intention is to engage with the public and to demonstrate to them that these issues that Jessica, you were just saying, might not necessarily feel as immediately pertinent to the wider audience. Once you have looked more closely, they then become much more important, much more pertinent, because at the end of the day, they affect the very idea of what we stand for as a community, as a society, as a liberal democratic state, and whether we are running the risk of losing that identity. I believe one of our participants was saying that this is a battle for the psyche of this country, and for the identity of this polity. And I agree. The scene in isolation, the various developments that you have both provided such accurate reflection on, may not necessarily create agony about tomorrow. But taken in combination, they quickly demonstrate the serious threats that we're currently faced with. We will continue our discussion and analysis of the threats that we're currently facing in the context of that wider debate about this new winter of discontent. And we will be doing that on the eve of International Human Rights Day, when we will focus on the plans of this government for the Human Rights Act and our future relationship with the European Convention on Human Rights. Thank you so much, Dominic. Thank you very much, Jessica. We are very privileged, very honored to have you both as visiting professors at Goldsmiths, and very much looking forward to continuing this conversation and to be working together when faced with such serious threats to liberal democratic values. Thank you very much, everyone, for your attention. We will be sharing the link.
Thank you very much. Really enjoyed doing it. And thank you, Jessica.
Thank you. Thank you both.
Thank you both. See you all soon. Thank you very much.
Bye.
Bye.